Welcome to the deep dive. Today we're tackling a really central part of company law,
We are indeed. Directors' ditties?
specifically under Part 10 of the Companies Act 2006. It's fundamental stuff.
Absolutely essential.
And look, we're going to be drawing heavily on some fantastic materials today.
Really invaluable, yeah.
They've been made available by the University of London, and we want to say a big thank you to them.
Definitely. Great resources.
Just so everyone's clear, this deep dive is purely for educational purposes. We want to help you, our listener, really get to grips with this.
It's a complex area, so hopefully we can break it down.
And we also want to thank our sponsor. This deep dive is brought to you by Sinorbit Academy, Sri Lanka.
Right. So our aim today, it's really to unpack these duties, highlight the core ideas, the key sections, and importantly, the cases that bring them to life.
Yeah, give you a clear roadmap, especially if you're, heading towards exams.
Make it stick and help you feel prepared.
Exactly. And on that note, a massive good luck to everyone who is studying right now, especially for exams.
Yes, best of luck.
Okay, so let's kick off. Why? Why do we even have these specific legal duties for directors? What's the basic problem here?
Well, it boils down to power and trust, doesn't it? Directors have huge power.
Over the company's assets, its direction.
Exactly. And that power is supposed to be used for the company's benefit. But, directors are people. They have their own interests.
So the risk is they might put their interests first or just, misuse the power.
Precisely. So the law steps in with duties, they set the standard, the boundaries, and crucially, they provide remedies if things go wrong, incentives and consequences.
And these rules didn't just spring up with the 2006 Act. They've got history.
Oh, absolutely. Deep roots in case law. Equity played a huge part, thinking of directors almost like trustees, needing fairness, loyalty.
The fiduciary idea.
Exactly, the fiduciary status.
Okay.
And then common law developed the duty of care side through precedent, negligence concept.
So we had this body of case law, maybe a bit sprawling, a bit complex.
Yeah.
How did we end up with this neat list in the Companies Act?
Well, there was a long debate. Flexibility of case law versus the certainty, the accessibility of having it written down in statute.
The classic trade-off.
Right. And bodies like the Law Commission, the Company Law Review Steering Group, they looked into it extensively.
And they landed on codification or restatement.
Restatement, really.
Yeah.
The idea was to capture the essence of the existing common law and equitable principles in the Act. So Part 10 gives us sections 171 to 177, the general duties.
And a really important point you mentioned earlier, Section 179.
Ah, yes, crucial.
Yeah.
Section 179. It says these duties are cumulative, meaning a director has to comply with all of them that apply. You can't say, oh, I met Section 172, so it doesn't matter. I breached Section 175. If both apply, you have to meet both.
Okay, that's clear. Now, a vital point for anyone studying this, the Act uses quite general language. So how do we actually, interpret Sections 171 to 177? What happened to all that old case law?
It didn't disappear. This is where Section 170, subsection 4 is absolutely key.
Section 174.
Scott, it explicitly says the statutory duties must be interpreted and applied in the same way as the old common law rules and equitable principles they replaced. Judges must look back at that case law.
So the message for students is you cannot ignore the old cases. They're not just background. They are essential to understanding what the sections actually mean in practice.
100%. You can't grasp Section 175 on conflicts without knowing Regal Hastings or Section 172 without Rees Smith and Fawcett.
Yeah.
The cases give the detail, the context.
Right, the flesh on the bones, as you said. Okay, and another potential point of confusion. Who are these duties owed to? The company, shareholders, someone else.
Section 170, subsection 1 gives the straightforward answer.
S-171.
The duties are owed to the company. The company itself is the legal entity they serve.
And that reflects the old cases.
Yes, it confirms a long-standing rule from cases like Percival v. Wright. Directors generally don't owe these duties directly to individual shareholders.
So if there's a breach, it's the company that has the right to take action against the director.
Primarily, yes. The company is the proper claimant. And now that's different from the question of whose interests the directors need to consider when doing their job. That's about the content of the duties, especially Section 172.
Okay, perfect distinction. Let's list those 7 general duties again, just to have them clear. Sections 171 to 177.
Go for it.
Right. 1, duty to act within powers. That's S.171. 2, duty to promote the success of the company. S.172.
The big one?
3, duty to exercise independent judgment, S.173. 4, duty to exercise reasonable care, skill, and diligence, S.174.
The competence duty.
5. Duty to avoid conflicts of interest, S.175. 6. Duty not to accept benefits from third parties, S.176.
The no bribes rule, essentially.
And 7. Duty to declare interest in proposed transactions or arrangements, S.177.
That's the set.
Let's zoom in on Section 172 first. You called it the big one. Why is that?
Well, it's often seen as the core duty. It sets the overall objective. Directors must act in the way they consider, in good faith, would be most likely to promote the success of the company.
And here's the key part.
For the benefit of its members as a whole. Members meaning shareholders, generally.
And then there's that list of factors in point 1721. They need to have regard to employees, suppliers, community, environment, reputation.
Yes, that list.
Where?
The standard view, the sort of enlightened shareholder value approach, is that directors consider these factors, because doing so helps achieve long-term success for the shareholders.
So it's instrumental, like looking after your employees is good for productivity, which is good for profits, which benefits shareholders.
Exactly. Or managing environmental impact avoids fines and reputational damage, which again protects shareholder value. It's not generally seen as balancing shareholder interests against these other factors, but using these factors to achieve shareholder benefit, though there are, debates around stakeholder theory.
Understood. Now, that phrase, in good faith, in Section 172, how is that assessed? Is it objective?
No, this is crucial.
Yeah.
It's subjective. The key question isn't, was this decision objectively the best one? Or would a reasonable director have done this?
Yes.
It's, did this director honestly believe that their actions were likely to promote the company's success?
So their state of mind.
Precisely. Think of Parker J. in Region Crest Paley Cohen. He said the question is whether the director honestly believed it was in the company's interests. Or even earlier, Lord Green in Rees Smith and Fawcett Ltd. Directors must act bona fide in what they consider not what a court may consider is in the interests of the company. Remember Rees Smith and Fawcett.
So even if their belief seems a bit odd or even wrong in hindsight?
That's the general principle. The recent Client Earth v. Shell case confirmed this. The court reiterated that the S172 test is subjective, focusing on the director's actual belief, even potentially if that belief might appear irrational to an outsider.
Wow. That makes challenging a board's decision under S172 quite difficult then, doesn't it? Proving dishonesty.
It does. It's a high bar. And this is important to remember, Section 179, the cumulative duties.
Yes, they all apply.
So a director might honestly, subjectively believe their wacky decision is good for the company, potentially satisfying S172. But if they reach that belief completely negligently, without proper thought or information,
they could still breach Section 174, the duty of care.
Exactly. Even if they escape S1172 because of the subjective test, their lack of reasonable care, skill, and diligence might catch them under S174.
That makes sense. Now, there's a really important exception, or maybe a shift in focus, within Section 172 itself, isn't there, when things go financially wrong?
Yes, absolutely critical. Section 172, subsection 3, S by 1723.
What does it say?
It modifies the primary duty. When the company is insolvent, or potentially approaching insolvency, the director's duty to promote the success of the company becomes subject to any rule requiring them to consider or act in the interests of creditors.
So the focus shifts away from just the shareholders.
Yes. Once the company's solvency is doubtful, the creditor's money is effectively what's at risk, so their interests become paramount, or at least need to be considered.
And there was a huge Supreme Court case recently that clarified exactly when this duty to creditors kicks in.
That's right. BTI 2014 LLC v. Sequana SA, a landmark decision. Sequana.
What did Sequana decide about the trigger point?
It decided the duty to consider creditors' interests is triggered when the directors know, or ought to know, that the company is insolvent or bordering on insolvency, or that an insolvent liquidation or administration is probable.
Probable, not just possible.
Probable, meaning more likely than not. That was key in Sequana itself. The company paid a large dividend. There was a risk of a future liability making it insolvent, but at the time the dividend was paid, the court found insolvent liquidation wasn't actually probable. So the duty hadn't been triggered yet.
And once it is triggered, how does the duty change? Is it all or nothing?
Sequana talked about a sliding scale. When insolvent liquidation is probable, directors need to balance the interests of creditors alongside shareholders. But if things deteriorate further and insolvent liquidation becomes inevitable, then the creditors' interests become paramount. They must be prioritized.
Are we talking about specific creditors or the whole group?
The creditors as a general body, a class. Cases like GHLM Trading Ltd v. Maru make it clear directors shouldn't improperly favor one creditor over others. Think GHLM Trading.
Is this duty to creditors also subjective? Does the director just have to believe they're acting in the creditor's best interests?
Yes, that seems to be the case. Wesley v. White suggested it remains a subjective test. Did the director honestly believe this was best for the creditors? But again, S174 looms. If they reach that belief negligently, that's still a potential breach of the duty of care.
And enforcement when the company is insolvent.
The duty is still owed to the company, but it's typically the liquidator or administrator who will sue the directors for breach, acting on behalf of the company and its creditors. And Sequana made another crucial point. Shareholders cannot ratify or forgive a breach of this duty once it's triggered if it prejudices the creditors.
That makes sense. How does this S.172 duty compare to wrongful trading under Section 214 of the Insolvency Act? Students often get asked about this.
Good question. It's a key distinction. Wrongful trading under S2110IA, 1986, typically triggers when directors knew or should have concluded that there was no reasonable prospect of the company avoiding insolvent liquidation, essentially, when it's inevitable.
Whereas the S.1723 duty post-Sequana
Triggers earlier, when insolvent liquidation is merely probable. So, directors need to start thinking about creditors' interests potentially well before they might be liable for wrongful trading. That probable versus inevitable distinction is vital.
Okay, Sequana is clearly a must-know case. Let's shift back to Section 171, duty to act within powers. Two parts to this.
That's right. First part, S171A, is acting in accordance with the company's constitution, its articles, resolutions, etc. Remember, Section 33 says the Constitution binds the company and members.
Straightforward enough. And the second part, S171B.
This is the duty to only exercise powers for the purposes for which they are conferred. The proper purposes doctrine.
Which, again, comes from older cases.
Yes, like Reesmith and Fawcett. The classic example is the power to issue shares.
Proper purpose. Raising capital for the company.
Right. Improper purpose. Issuing shares mainly to dilute a troublesome shareholder's voting power, or to ensure your side wins a takeover battle, or to entrench management control. That's using the power for a collateral purpose. Think Piercy vs. Mills & Co., Ltd.
And the main case setting out the test for whether a purpose is proper.
That's Howard Smith, Ltd v. Ampol Petroleum Ltd. A Privy Council case, but highly influential. Howard Smith.
What did Howard Smith establish?
It said you have to look at the power in question, like issuing shares, identify the purpose for which it was granted, usually raising capital, and then assess the substantial purpose for which the directors actually exercised it.
Even if the directors honestly thought they were helping the company overall.
Yes. Lord Wilberforce in Howard Smith made it clear that even if directors act in good faith, believing it's in the company's best interests, potentially satisfying Council 172, if their dominant reason for using a power is improper, like manipulating voting control, they still breach S.171B. It's an objective assessment of the purpose, distinct from the subjective good faith test in S.172.
Got it. Objective purpose for S171B, subjective belief for S172. Okay, next up, Section 173, duty to exercise independent judgment. What's the core idea here?
Simply put, directors have to use their own judgment. They shouldn't just blindly follow instructions from someone else or subordinate their decision-making. They need to bring their own mind to the table.
What about practical situations like nominee directors? They're appointed by a major shareholder, often to represent that shareholder's interests.
That's a classic tension. Section 173 makes it clear. Even a nominee director owes their duties, including this one, to the company. They must exercise their independent judgment in what they believe is best for the company, not just act as a mouthpiece or puppet for their appointer.
And delegation. Boards have to delegate tasks.
Of course. Running a company requires delegation. Section 173(2)B explicitly allows this. It says the duty isn't breached if a director acts in accordance with an agreement duly entered into by the company that restricts future discretion, or in a way authorized by the company's constitution. Most constitutions, like the Model Articles, permit delegation.
So delegating functions according to the rules is fine. What about S.1732? Does it mean directors can back out of contracts?
No, quite the opposite. It prevents directors from using S.173 as an excuse to get the company out of a binding contract it has entered into.
Yeah.
Just because the directors later change their minds, the company remains bound.
Okay, that covers powers, success, independence. Now Section 174, The duty of care, skill, and diligence. This feels different from the others.
It is. The others 171, 172, 173, 175, 176, 177 are primarily about loyalty, good faith, avoiding conflicts. They're often called fiduciary duties. Section 174 is about competence. Are you doing the job properly?
And how is that judged? What's the standard?
It's a two-part test set out in SBUT 1742. First, there's an objective minimum standard. The care, skill, and diligence that would be exercised by a reasonably diligent person with the general knowledge, skill, and experience reasonably expected of a director carrying out those functions.
So a basic level expected of anyone in that role.
Yes, but then there's a subjective element on top. If a particular director has greater general knowledge, skill, or experience than that objective baseline, they are judged by that higher standard.
So if you appoint an expert accountant to the board, they can't just perform like a director with no financial background. They have to use their expertise.
Precisely. Their special skills raise the bar for them personally. The case Ray Don of London Ltd., although pre-act, illustrates the general idea. Director signed an insurance proposal form incorrectly without reading it properly. Breach of duty of care. He was negligent.
Even though it was an own company.
Yes, the standard applies. That objective, reasonable director wouldn't have done it, and maybe subjectively he should have been more careful too. Ray Dion is a good reference point.
Right. Now for the big cluster of no conflict duties. Sections 175, 176, 177. These feel very central to being a fiduciary. Let's start with the main one, Section 175.
Section 175 is broad. It's the duty to avoid a situation where the director has, or can have, an interest, direct or indirect, that conflicts, or possibly may conflict, with the interests of the company.
Possibly may conflict. That sounds strict.
It is strict. The idea, famously put by Lord Herschel in Bray v. Ford, is prophylactic. It's designed to prevent directors from even being tempted by a conflict. So it's not just about acting honestly if a conflict arises, it's about avoiding the situation in the first place.
So avoid the situation itself. And Section 175(7) clarifies what counts as a conflict.
Yes, it makes clear it applies to conflicts between the director's personal interest and the company's interest, but also conflicts between the director's duty to the company and their duty to another person.
Like being a director of two competing companies.
Exactly. That overturns some older, more relaxed cases and confirms the stricter modern approach we saw in cases like SCWS v. Meyer.
A really key application of S175 is the corporate opportunity doctrine, right?
Mentioned in S.175.
Yes, absolutely central. Section 175(2) applies the general duties specifically to the exploitation of any property, information, or opportunity belonging to the company or which the director became aware of as a director.
And the case everyone needs to know for this
Has to be Regal, Hastings, Ltd v. Gulliver, the absolute classic. Regal Hastings.
Remind us of the facts and the ruling.
The company wanted to acquire leases of 2 cinemas to sell the whole group as a going concern. It formed a subsidiary but couldn't afford to subscribe for all the shares needed to satisfy the landlord. So, the directors personally subscribed for the remaining shares. Later, the whole business was sold, and the directors made a profit on their shares.
And they acted honestly. The company benefited.
Yes, the directors acted in good faith. The company itself couldn't afford the shares, and the transaction ultimately benefited the company overall by allowing the sale to go through. But the House of Lords said none of that mattered.
Why not? Lord Russell said they got the opportunity and the resulting profit by reason of the fact that they were directors and in the course of the execution of that office. Because the opportunity came to them as directors, they were liable to account for the profit to the company. Strict liability.
And S175 reinforces that now?
Yes, it says it's immaterial whether the company could take advantage of the opportunity. That directly reflects Regal Hastings.
What about the Cooley case? Industrial Development Consultants Ltd v. Cooley. He resigned first.
Didn't help him. Mr. Cooley was managing director of IDC. A third party approached him personally, saying they wouldn't deal with IDC, but would give the contract to him. He feigned illness, resigned from IDC, and took the contract himself.
And the court said?
Liable. The information and opportunity came to him while he was managing director. His resignation was part of the plan to take the opportunity. He had a duty to pass that information on to IDC, breached S.175.
Does the opportunity have to be squarely within the company's existing business?
Not necessarily. O'Donnell v. Shanahan suggests the rule is strict here, too. Directors diverted a property investment opportunity, arguing it was outside the company's actual business scope. The Court of Appeal said that didn't matter. The opportunity came to them as directors, so they couldn't take it personally without consent. Very strict UK approach. Remember O'Donnell.
Can this duty bite even after a director leaves?
Yes. Section 170, subsection 2, remember S1702, it keeps the S.175 duty and 1.176 alive regarding things the director learned about or opportunities they became aware of while they were a director.
So you can't just resign to grab an opportunity you found out about yesterday.
Generally, no. But there is some nuance in the case law post-resignation.
How so?
Liability seems less likely if, 1, the resignation wasn't primarily driven by the desire to take the specific opportunity, and 2, the opportunity wasn't something the company was actively pursuing, a maturing business opportunity.
Cases to illustrate this.
Contrast, Island Export Finance Ltd v. Umuna, where a director resigned and later won a contract from a former client he wasn't liable. With CMS Dolphin Ltd v. Simonet, where a director resigned, took staff and clients, and exported an opportunity the company was developing, he was liable. Umuna versus Simonet. Also, Thermoscan suggests using general skill and knowledge post-resignation is fine, but taking specific trade secrets or opportunities isn't.
Okay, so it's strict, but maybe slightly less so after an honest resignation if it's not a maturing opportunity. Can directors get permission to take a potential conflict situation? Avoid breaching S.175.
Yes, the Act provides authorization routes in S1755 and 6.
How does that work?
For private companies, the conflict can be authorized by the other directors, the ones who aren't conflicted, unless the company's constitution forbids it.
And for public companies?
For public companies, authorization by the board is only allowed if the company's constitution expressly permits it.
And a key condition.
The director, with the conflict, cannot count in the quorum or vote on the resolution authorizing the conflict. That's S.1756. They have to be genuinely independent directors making the decision.
Okay, that's authorization for S.175 conflicts. What about Section 176 not accepting benefits from third parties?
This is a bit more specific than S.175. It prohibits accepting a benefit from a third party, which is given either because the person is a director or for the director doing or not doing something as a director.
Like a bribe or a secret commission.
Exactly. Think kickbacks from suppliers. Lavish gifts intended to influence decisions. There's an exception in S.1764 if accepting the benefit can't reasonably be regarded as likely to give rise to a conflict. And benefits from the company itself are obviously fine.
Can the board authorize a breach of S.176?
No. Unlike S.175, board authorization is not available for S.176. Only the shareholders can authorize or ratify acceptance of such a benefit under Section 184.
Got it. Board can authorize S.175 conflicts, sometimes, but only shareholders can approve S.1176 benefits. Now, Section 177, this is often confused with S.1175. How is it different? It's about interests in transactions.
Yes, S.177 deals with self-dealing. Section 175 helps clarify. If a situation falls under S.177, then S.175 doesn't apply. Section 177 applies specifically when a director is in any way directly or indirectly interested in a proposed transaction or arrangement with the company.
So S.175 is about avoiding conflict situations generally, while S.177 is about what you must do when the company is actually considering a specific deal you have an interest in.
Exactly. And the duty under S.177 is primarily one of disclosure. The director must declare the nature and extent of their interest in that proposed transaction to the other directors.
When must they declare?
Before the company enters into the transaction. That's S.1774.
How much detail?
Needs to be pretty precise. Gwembe Valley Development Co., Ltd v. Koshi, stressed the need for sufficient detail. Gwembe Valley. And it needs to reach the whole board, though it can be informal, according to Lee Panavision Ltd v. Lee Lighting Ltd., but everyone needs to know.
Are there exceptions? When don't you need to declare?
You don't need to declare under S.177 if the interest couldn't reasonably be regarded as likely to give rise to a conflict, or if the other directors already know about it or ought reasonably to have known, like if the transaction is directly with the director themselves.
And there's a separate criminal provision, too.
Yes, Section 182 requires disclosure after a transaction is entered into if it wasn't declared properly beforehand under S.177. S.182 is the backstop.
Okay, so for many proposed transactions where a director has an interest, declaring it to the board under S.177 is the key. But sometimes that's not enough, right? Sometimes you need shareholder approval.
That's correct. For certain types of transactions considered higher risk, Chapter 4 of Part 10 imposes stricter rules requiring shareholder approval by ordinary resolution. Disclosure to the board alone isn't sufficient for these.
What kind of transactions are we talking about?
The main ones are substantial property transactions, that's Sections 190 to 196, Loans, quasi-loans, and credit transactions involving directors sections 197 to 214. Directors' long-term service contracts over 2 years, section 188. And payments for loss of office sections 215 to 222.
Let's just briefly look at substantial property transactions, SPT, section 190. What's the trigger?
An SPT occurs when a company enters into an arrangement to acquire a substantial non-cash asset from a director or a person connected with a director, or sells such an asset to a director or connected person.
What counts as substantial?
Section 191 defines it. It's an asset whose value either exceeds £100,000 or exceeds 10% of the company's net asset value and is more than £5,000.
And connected person.
That's defined broadly in sections 252 to 255. It includes family members, companies the director controls, trustees of trusts benefiting the director or family, etc. It casts a wide net.
And if a company does an SPT without getting shareholder approval first?
The transaction is voidable by the company, and the director involved and any other director who authorized it can be liable to account for profits or compensate for losses. That's section 195. So getting shareholder approval for these deals is crucial.
Okay. We mentioned shareholders approving things. What's the difference between authorization and ratification?
Good point. Authorization is approval given before the director acts or before the transaction happens. If validly given, example under S175 or S1804 or Chapter 4, it prevents a breach from occurring in the first place. Ratification under Section 239 happens after a breach has already occurred. It's the shareholders effectively forgiving the breach and validating the director's actions retrospectively.
Are there limits on what shareholders can authorize or ratify?
Yes. Firstly, for either, there must have been full and frank disclosure of all material facts to the shareholders. Cases like Cullen Investments Ltd v. Brown emphasize this.
And for ratification specifically, Section 239.
A key protection here, under Section 239(4), is that when shareholders vote on ratification, the votes of the director who committed the breach and any member connected with them are disregarded. Their votes don't count.
That prevents the wrongdoer from just using their own shares to excuse themselves.
Exactly. Though there's still some old common law uncertainty, preserved by the Act S184, S2339, about whether really serious breaches, like fraud on the minority, can be ratified even by genuinely independent shareholders.
Okay. So if a breach does happen and isn't authorized or ratified, what remedies can the company seek? Section 178.
Section 178 confirms that the consequences for breaching the general duties are the same as they would be for breaching the corresponding common law or equitable rules.
So for the fiduciary duties like breach of S172 or S.175, we're looking at equitable remedies.
Right, things like, yes, equitable compensation for loss suffered by the company. Think Lands Allotment Co.
Getting property back.
Restoration of company property transferred away in breach of duty. Reforest of Dean Coal Co.
What about profits the director made?
An account of profits. The director has to hand over the personal profit they made from the breach. Regal Hastings is the prime example again.
Anything else?
Injunctions to stop a breach, declarations about the director's liability, or rescission of contracts entered into where there was an undisclosed conflict. Transvaal Lands Co. v. New Belgium for rescission.
So, quite a range of remedies. Is there ever a way out for a director who has technically breached a duty but perhaps didn't mean harm?
There is a potential escape route, yes. Section 1157 of the Companies Act, S10157.
Relief from liability.
Exactly. It gives the court discretion to relieve an officer, including a director, from liability for negligence, default, breach of duty, or breach of trust.
What are the conditions for getting relief under S1157?
The director must convince the court of three things: that they acted honestly, that they acted reasonably, and that, considering all the circumstances of the case, it would be fair to excuse them, either wholly or partly.
Honesty, reasonableness, and fairness. Are courts generous with this?
Not especially. The Riddon case, again, the director who signed the form without reading was found to have acted honestly but not reasonably. However, because the breach mainly harmed himself and it was a small company, the court thought it fair to grant him partial relief, reducing his liability.
But if the director clearly intended to profit,
then relief is highly unlikely. Courts are reluctant where there's self-interest involved. Look at Redduck Warrability No. 2 or Towers v. Premier Waste Management Ltd. Honesty and reasonableness are hard to show then, and fairness usually dictates holding them liable. It's a high hurdle.
Okay, we've covered a huge amount of ground. If you're listening to this for study purposes, what are the absolute key takeaways to focus on?
All right, let's nail this down. First, understand why these duties exist, the power trust issue. And their history, common law, and equity feeding into the statute.
Know the structure of Part 10, the 7 duties, S.171 to S.177. And critically, Section 174, the link back to case law. You need the cases. Remember Percival v. Wright, for who the duty is owed to, the company, S.170. And S.179, cumulative duties.
Definitely. Then for specific duties, S-172, know the subjective good faith test. Regent Crest, Smith and Fawcett Client Earth. And the massive importance of the creditor's interest duty under S-1723, know the Sequana trigger, probable insolvency, and the sliding scale.
Section 171, proper purposes doctrine, the objective test from Howard Smith. Section 173, independent judgment, especially for nominees. Section 174, the objective subjective standard of care, read ban.
Then the conflict cluster, S-175, avoid the situation, Bray v. Ford. Master corporate opportunities, Regal Hastings, Cooley O'Donnell, or non-negotiable. No S.1702 on post-resignation liability, contrasting Umuna and Simonet. Understand board authorization under S.1756.
Section 176, benefits from third parties, shareholder-only authorization. Section 177, declaring interest in proposed transactions, know the timing and disclosure needs. And know the big transactions needing shareholder approval, like SPTs under S.110.
Finally, authorization versus ratification, S-239, especially the non-counting votes rule, remedies under S-178, kind of profits, compensation, etc., and the possibility, but difficulty, of relief under S-1157. Repeat the section numbers, repeat the case names.
Absolutely. Practice applying them. Take a scenario, ask, which duty applies? S-172 and 57, S-175. Both. S-179. What's the test? Which cases help? Breach? Remedies S-178. Possible relief S-1157. Who can sue? It's about connecting all these parts.
It may be a final thought. It's this constant tension, isn't it, between setting clear rules directors must follow, which the statute tries to do, and allowing them the flexibility needed to actually run a business and take commercial risks.
Yeah, and the courts are always navigating that line, using the old case law to interpret the newer statute.
It keeps it a really dynamic and honestly fascinating area of law, always evolving.
It certainly is. Well, that brings us towards the end of this particular deep dive. We've worked through those core director's duties in the Companies Act 2006, trying to link the sections to the key cases and concepts.
Hopefully that provides a solid framework. But remember, there's always more detail. We really encourage you to go back to those excellent source materials provided by the University of London.
Yes, dive deeper into those. And a final thank you to our sponsor for making this possible, Sinorbit Academy, Sri Lanka.
Thanks for tuning in.
And from both of us, truly good luck with all your studies and any upcoming exams. Keep diving deep.